the writ is, I think, order 6, right? And then service, order 10. Service out of jurisdiction, order 11. I can't remember what 12 is. Okay, so 13 is about expiration of AS, so default judgment in judgment in default of AS. 14, in between you can slip in a summary judgment if you want. Okay, and then everything follows. The order 18 is about pleadings, etc., etc. It briefly follows the chronological order. Even when you look at things we just look at, sanction payments, right? It follows sort of chronological order as well. 23 is a notice of payment, 24 is a notice of acceptance. You notice that? Right? It sort of flows. Okay? If you are totally stuck, at least put in the order number if you cannot remember the real number. Don't give up. Okay? Of course it's not as good. Otherwise everybody will get the same marks, right? But at least try to put in the order number. But it's just the order number in most cases is too vague. Okay, but everything is roughly in chronological order. Do you guys still remember how to look for legislation? You do, right? For those that can't remember, please remind me at the end. We definitely will have some spare time. So if you need quick revision about where things are, let me know. Okay, going on now. I'm not going to bother with that. Okay. Where will we? Question 5B is where we are up to, right? Security for cost. Whose application? Defendant's application. Very good. It's one of those rare things that the defendant can apply, right? What's the basis? What is the defendant saying to the court? Or do you remember what is so special about the plaintiff in the cases that the defendant applies under Order 23? The defendant is normally the defendant is saying, well, defendant is saying I have a strong case of defense. I'm being put into inconvenience to defend this action, so wasting my time and wasting my cost. What's the basis? Security for cost. Look at what is called security for cost. I want to make sure, right? Security is like sort of as it sounds, right? Is to ensure what? Is to ensure that the defendant saying, I want to ensure that if I win my case of defense and the plaintiff loses, I want to make sure the plaintiff has money to pay for my legal costs. So you remember that? Okay. So, what's so special about those plaintiff or the plaintiff in those cases normally? They're normally ordinarily resident overseas, or they are nominal, like shell company, with no assets in Hong Kong. It can be both, but at least one of those. Okay. So, because the defendant's got to have basis to apply for the security for cost. Why is the defendant so worried? Right? It's on the basis that either the plaintiff resides overseas, so even if the defendant wins, it's hard for the defendant to catch, okay, the plaintiff to pay the cost, especially if the plaintiff has no assets within Hong Kong. Okay? So that's the basis. Procedure under Order 23, again, inter partes summons and affirmation. need to have materials to decide on the quantum under the application for security for cost. The quantum here is not about damages, it's about, well, you're asking for security for cost. How much are you asking for and on what basis? Okay, so you say, you're worried nobody can pay your cost. Well, tell us what's your estimation of your cost. So you need materials before the court or to be submitted to the court to decide how much is the amount for the security for cost. Hearing is normally before a master in chambers. Circumstances for making the application. Plaintiff is ordinarily resident out of the jurisdiction. Or plaintiff is a nominal plaintiff and there's reason to believe he will be unable to pay the defendant's cost. Normally they will argue that, yes, my case of defense is strong, plaintiff's case is weak. I think he's likely to evade paying the cost if the plaintiff loses. There can be, sometimes it can be sought, this order can be sought due to incorrect or lack of address for the plaintiff on the writ, or there is reason. There is some sort of hint or reason showing that the plaintiff has, it's not just incorrect, it's almost suggesting the plaintiff is deliberately putting on a wrong address so as not to be caught. So there's a hint of that. So if it's just an incorrect, you can ask the plaintiff to amend it, right, or to specify the correct address. But the hinting there is that, no, the plaintiff's not giving me the correct address of this. So I think he's going to try to evade the consequences if he loses. The plaintiff has changed his address, sometimes multiple times, to avoid the consequences of litigation, as in losing the case. Defendant basically has to show that defendant has a strong defense, and that, of course, by contrast, plaintiff's case of the claim is weak. Defendant is put to inconvenience at the expense of defending the action. So, okay, remember to cite relevant rules and PD just as the exact question. Be mindful of time limitation because this is a half questions. These are half questions, 5A and 5B. Okay. Although I do not set the exam paper, but if you go back and look at past papers, you would get a general idea of which questions tend to be half questions. Okay. So you will see, you can, when you prepare your notes and your practice runs of doing the mock or past papers, you would know that those tends to be shorter questions. Okay, summary judgment. Overall structure, explain the concept of Order 14. Define summary judgment. What's the purpose? Why do the court have this? Why do our rules have this mechanism? Understand the prerequisites. This must be fulfilled. When we say prerequisites or preconditions, it means these circumstances must, or criteria must exist before you can actually start applying or making an application for Order 14 summary judgment. The writ must have been properly served on the defendant. Defendant returned the AS, acknowledgement of service indicating an intention to defend the action. Affirmation must be valid and not defective. Application procedure, surprise, inter partes, summons, and affirmation. Requirements of the affirmation, such as the affirmant saying, yes, I believe the defendant has no arguable defense and no tribal issues. The effect of a valid application by the plaintiff, then, after the application is made, the burden is then shifted to the defendant to show why the summary judgment should not be granted. Defendant would only file an affirmation in opposition, okay? In opposition to show basis of the defense. affirmation in opposition to show basis of defense. The hearing procedure again is heard before master. Explain the difference between the call overhearing, which we sometimes call the return date, and the substantive hearing. Okay, when you come back a second time, if the first time, because the first time the call overhearing is about 15 minutes. The second time is if there needs to be more substantive arguments allowed, then it would be adjourned to a second or substantive hearing. Principles on summary judgments. The plaintiff should be entitled if the defendant has no arguable defense and there are no triable issues that justify the case going to full trial. Not meant to be a mini trial. I'm not listing all the principles here. You have to go through them. Okay? In an exam or in your assignment, you have to go through the principles. 4 possible outcomes. You should be able to explain under what circumstances would what each of the 4 outcomes would be given or granted by the court, as well as the consequence. So again, I'm going brief on this because you have the lecture notes and because this is an assignment question. However, pointers to note to avoid pitfalls: must explain both procedures and principles clearly. Okay. Especially also, like some other questions, the question do not spell out. Please explain all principles, please cite all authorities. You should be used to doing that for all your questions. Don't forget to apply the facts given. Question is asking you to advise. So, for example, in our question 6, let's have quickly look at question 6 here, given to you on page 39. So Helen Mann has sold and supplied to Rita Soul a large quantity. Why I'm laughing is Rita Soul is the name of the actual master or deputy judge in court. Okay, Helen Mann has sold and supplied to Rita Soul a large quantity of computer parts for the price of $2 million. All goods are of merchantable quality and were delivered on time. So, despite many demands to pay, Rita has failed to do so. Helen has served a writ on Rita. Rita has returned the AS, indicating an intention to defend. What advice will you give Helen concerning Order 14 under rules of High Court? You should clearly explain the procedure involved and cite any relevant case law. Okay, so what are the facts given to you? Why are the facts given to you? It is to show you that it is likely the defendant's case is very weak. Is that right? No? Goods delivered according to under the contract on time. The goods doesn't appear to have any problem. Okay. The other side has simply, or Rita has simply failed to pay. As well, you should note whether the preconditions have been fulfilled. Okay. That gives you the basis of advice. Okay. So when you answer a question like this, you should try to mix in or build on some of the facts, okay, to make it more relevant. So if you compare question 6 and question 12, what's the difference? Now let's look at question 12 on page 49. So what's the difference? You have to identify what's the difference. We give you questions, what your focus, how your focus can sometimes differ. Question 12 is like a very theoretical, purely legal question. Summary judgment is meant for clear-cut cases where the defendant has no arguable defense to the plaintiff's claim. Do you agree with this statement in relation to Order 14 of the Rules of High Court? In your answer, you should clearly explain the procedure involved and cite any relevant case law. Okay, apart from, well, for both questions, you have to explain the definition, the procedure, the basis, and the principles. Cite all rules and relevant case law. That's a must. The difference between question 6 and question 12 is that there are facts given in question 6, correct? So you are expected to apply some of those facts to mix it in your discussion. For 12, the focus is pretty much on clear-cut cases. You agree? Right? It's meant for clear-cut cases. So your concentration of discussion would be more on the principles, although you still explain the procedure, explain the definition, and so on and so on. You should fill in the gaps more there and discuss as many principles as you can regarding that it's a high hurdle, it's meant for clear-cut cases, it's not meant to be a mini trial, those principles, right? And you have to, if I were you, I would even suggest, if you remember enough, some cases cannot qualify, or you cannot apply for summary judgment for some cases. Can you remember any example? Defamation? Fraud? Some that are by the nature of the case itself too complex, deemed to be too complex. You need to examine the minute details. And because such case, it may become a mini trial if an Order 14 application is made. Those are already excluded from the type of cases that you can apply for summary judgment under Order 14. So I'm just giving you an example. You don't have to list out all the broad definitions, okay? But this is to give you an example of what you can argue. There are many ways you can argue for question 12, right? But go along the lines, because the focus is, it's got to be a clear-cut, meant to be a clear-cut case. Do you agree? So please remember to answer whether you agree. Okay. So of course it doesn't stop there. Do you agree? If you agree, why? If you don't agree, why? Of course. And in your other subjects, again, going to other subjects, if you have a question like that, do you agree? Then you would argue something each side would agree. Okay, if, of course, here we know Order 14 summary judgment applications are meant to be. But how do you mix in the other side's argument? I think predominantly, perhaps 90% of your discussion is to agree. Because it is by case law, it's meant to be for clear-cut cases. You can't really argue or conclude, and your conclusion cannot be otherwise. You can't really conclude and say, no, I don't agree because it really is not for clear-cut cases. I think it's hard to argue that way. You must really agree in the end. But if you want to spill some beans and muddle the waters a little, perhaps you can think about evidential issues. Perhaps you can mix in a little bit of, sometimes it's hard to define what's clear-cut and not. Okay, but make that light, because for Order 14, summary judgment applications, it pretty much is clear-cut cases. You may mix in a little bit of other arguments, but your main conclusion must be this. Okay, clear-cut cases only. But I'm saying for your other subjects, if you're asked to agree or disagree, you should put in a little bit of both sides' argument. But if it's as clear-cut as Order 14, then your final conclusion must be that it is for clear-cut cases. Okay? Because sometimes, especially for constitutional law and things like that, you're meant to argue, make more arguments from both perspectives. But here in your Order 14, it's difficult to conclude it's not. Okay, so your final conclusion must be that yes, it is for clear-cut cases. So throw in all your arguments, not for complex cases, not for heavily dispute where they're complex factual matrix, not meant to be a mini trial. And the hurdle is very high because the question is not whether the defense is to be believed. Okay? You don't prejudge, you don't make an early judgment. It's whether the defense is capable of belief, meaning is it ever possible? Okay, so it's a very high hurdle. So here I won't repeat, except that for question 12, as I said, you would go through this kind of principles. Okay, and then, of course, mix in your answer and state whether you agree. Okay, should all cover all aspects, and the principles here are meant to be discussed more in depth. Whereas for question 6, you're expected to apply the facts. Enforcement. Okay, I think you would at least need to go through this list. Okay, the actual question itself, on page 41, outline and explain the main methods of enforcement of a monetary judgment, which the plaintiff can take against the defendant. Notice it only asks you to discuss those that relate to monetary judgments. Okay, it doesn't ask you how you can take back vacant possession, etc., etc., okay, of land and things like that, or injunctions and so on. Okay, so concentrate only to on enforcement of monetary judgments, which the ones we have gone through. Writ of FIFA. Do you still remember what it is? What can you do? What do you do? First of all, for enforcement of enforcement of judgments in general, what kind of summons? Inter partes or ex parte? What kind of summons do you use to apply for most of this? Is it inter partes summons or ex parte? Very good. Okay? Because you don't want to tell the whole world you're coming after them. Right? You want to give them as short a notice as possible. Okay, so writ of FIFA, what do? What does the applicant or what's the word? Judgment creditor. Right? Remember that terminology? Judgment creditor. What does the judgment creditor do? What procedure is it? First of all, it is to learning on FIFA. Yes. Yes, very much so. So you engage. Well, what you're trying to do is to seize the judgment debtors' goods, okay, and hold them for 3 days. And if the judgment debtors still don't pay, you sell those goods to recover as much as you can. Now, next question: do you knock on the judgment debtor's door or break in? Who do you engage? Yes, you engage a court bailiff to do it for you. You have to pay a fee, but you engage a court bailiff to go to the defendant or judgment debtor's premises, seize valuable goods from the premises, and remember, normally it's the judgment debtor may be given a few more days to see if they pay. If they still don't, you would have the goods sold, normally at an auction, to recover as much as possible. The goods you seize can only be up to the value of the judgment debt. Okay, so if they owe you $1 million, the most you can seize is $1 million, assuming that they have such valuable goods. And also, you have to allow them some. Remember the personal bedding and clothing and tools of trade up to 10,000. Right, so that can be exempted. Okay, so those that is under Order 46 and 47. Charging orders. What is it? Again, ex parte application. By ex parte application, what do you do? First of all, what are you charging against? What kind of assets? Can be real property, as in landed property, or stocks or securities, right? Or unit trusts like that. Okay. So you charge against that. So what do you get when you actually apply? Ex parte application, affirmation, and then you get a charging order. What's a provisional order called? Charging order NISA. Okay. Most provisional, if you can't remember, is most likely to be NISA. Okay, NISI. So you get a charging order NISA, and what happens whenever you have a NISI? It's just like summons, right? So whenever you get an order NISI, normally how many days? Okay. After a certain period of time, it will become an order NISI will become absolute. Okay, so it's set in stone. Okay? So within which, if there is no cause to be shown why the charging order NISI should not be made absolute, after the expiration of a certain period of time, it would become absolute. And why do we want a charging order? What happens after we get the charging order absolute? We want to, well, we don't just want to put a hold on a premises. If we try to get, what are we trying to get? So we would want to, after we put a charging order on this, we want to sell it, right? So the next step, after we get the charging order, we would try to get an order for sale. Okay, that would be the next step. And then to recover whatever proceeds we get from it, we want to get paid. Okay? Garnishee orders. Garnishee orders. So we are saying a third party is involved. What are we saying in relation to the third party, and what's the relationship between the third party, the garnishee, and the judgment debtor? Who owes who money? Who owes whom? Third party, who is the garnishee? The third party is the garnishee, owes which party money? The judgment debtor money. So the garnishee owes the judgment debtor money. The plaintiff or the judgment creditor is saying, don't pay it to the judgment debtor, pay the money to me. Okay, so a typical example was a bank. A bank, the balance in the bank account is money due or owed to the judgment debtor. Okay, and that's why bank is a typical, and very frequently, the garnishee. The application is made to whom? If I'm the judgment creditor, I make an application, ex parte application. Who am I making an order against? The garnishee. Okay, don't confuse it. I'm not applying against my respondent, so-called respondent. I'm the applicant. The respondent or the party I'm applying the garnishee order against is the garnishee. Okay, the bank. I will also have to serve that garnishee order NISA to the bank. Okay, that's the party. That's one of the parties of the garnishee order. But I also serve it to the defendant or judgment debtor. Yes. Okay. But that's only to serve, to give him notice. But this proceedings is against the bank or the garnishee. Okay, so of course that's a garnishee order NISA when I apply. And again, the garnishee will be given a chance to show why that order NISA should not be made absolute. Okay, again. So otherwise, after the expiration of the time, and if the garnishee cannot persuade or justify why that order should not be made absolute, the order will be made absolute. And if the garnishee doesn't pay that money across to the judgment creditor, then the judgment creditor can enforce against the garnishee as well. Okay, what's prohibition orders about? Is it to prohibit the debtor from leaving his house? Yes, the prohibition order is to avoid or prevent the judgment debtor from leaving Hong Kong on the basis, okay, the plaintiff has to show that there is a very high chance, or it's very likely, first of all, that the judgment debtor is leaving Hong Kong with a sense of permanence, so not your weekend trip. Secondly, it has to be shown that if the debtor leaves Hong Kong this time, it's likely that the enforcement of the judgment will be prejudiced or delayed. Okay, will be avoided or delayed. Okay, with the paper. So we've gone through that. Allow plaintiff to seize, buy a court bailiff, defendant's goods, chattels, or other movable property. So the difference between FIFA is that writ of FIFA is movable property, chattels. Okay? Bailiff goes to premises and seize goods to the value of the judgment sum and cost. If judgment sum not paid after a certain time, goods can be sold at a reasonable price, normally at an auction under court's directions. Any proceeds realized would be given to the judgment creditor. Charging orders, ex parte application and affirmation. Okay, also beneficial interest in assets, specifically land or landed properties, unit trusts, stocks. Okay, charging order 9 served on judgment debtor, giving him at least 7 days notice of an appointment for further consideration. If the order is then made absolute, it will prohibit any dealing in the property by the debtor. If it's landed property, the judgment creditor would normally register that on the land registry to let everybody know that the property is charged. Garnishee order, third party, if a third party owes money to the judgment debtor, the court can make an order to order that garnishee to pay the money to the judgment creditor. Ex parte affirmation to apply, and the court will then seal an order nisa, serving it on the garnishee and the judgment debtor. The garnishee will be required or requested to attend court to persuade, if they want to, why the order nisa should not be made absolute. If the garnishee doesn't show up or cannot persuade the court why it should not be made absolute, it will be made absolute. Don't forget to mention the right to offset off, okay, on this as well. Prohibition order, where it is believed judgment debtor is about to leave Hong Kong with a sense of permanence, and as a result, payment of the judgment sum is likely to be obstructed, avoided, or delayed. Okay. Ex parte application supported by affirmation. A sealed copy, because it is to prevent the judgment debtor from leaving Hong Kong, immigration authorities will be notified. Okay. The judgment debtor will also be notified. Now remember this. Remember our lecture on enforcement. Don't confuse when it is ex parte and when it is inter partes. It is ex parte when we first get the order nisa in those cases, because we don't want to stop them in the middle of something. Okay, so when we get the initial order nisa, almost always it is ex parte. It doesn't mean that once we get the order nisa, we don't notify them. We always notify the other side. Okay, as you notice, everything is served on the other parties or the garnishee, etc. Okay. when we talk about ex parte application, it's the initial step that is ex parte. But we always serve on the other parties after we get the initial ex parte application. Any questions on this? Next question is on discovery. Wow. What a detailed question. Explain the operation of the process of discovery in a risk action. So, I guess that's why this is a cool question. Yeah. Okay, so because it can engage so many, right? When we talk about the process of discovery, depending on the length of the question, whether it's a full question or a half question. If it's a full question, you talk about automatic discovery, you talk about specific discovery as well. Right? You define what discovery is, you explain the duty of discovery, also that is a continuing duty. Okay, what's the purpose of discovery? No ambush, no surprises. Right? Don't use those words, but use the proper wording like disclosing to the other parties what documents you have, what evidence you have, so that the parties can assess and analyze all the evidence. Right? What is meant by documents? Remember, it includes paper documents, discs, recordings, WhatsApps, etc. Right? The test of relevance. Okay. So first of all, when we go through what we have to disclose under automatic discovery, disclosure, first of all, you have to do the list of documents. Do you still remember what's in Schedule 1, Part 1? First of all, what's the difference between Schedule 1 and Schedule 2? Right? Discovery involves all documents you have to disclose on the LOD, the list of documents. All documents that is or was in your custody, power, and control. Custody, power, and control. Okay. What's the difference between Schedule 1 and Schedule 2? Forget about Part 1, 2 first. Schedule 1 are the documents which you still now. Those documents under Schedule 1 are those that are still now in your custody, power, and control. Schedule 2 are the ones that once upon a time was in your custody, power, and control, but are no longer so. Okay, first of all, remember the difference between 1 and 2 first. Okay, then under Schedule 1, what's the difference between Part 1 and 2? Part 1 or Part 2? Part 2 are the ones that you're claiming privilege on. Okay, so remember Schedule 1 includes everything you now still have, still in your custody, power, and control. Part 1 are the ones you do not object, so you're happy to disclose them to the other side. Remember, disclosure includes giving photocopies of those documents, plus allowing inspection of the originals. Okay? Part 2 are the ones, yes, they are in my custody, power, and control, but I'm not showing it to you. Okay? I'm not producing those, and I'm not showing those to you. Okay? So, initially, under A here, disclosure of list of documents, and then production of those documents. Okay? Production meaning giving photocopies, inspection means, yes, I will state a time and place when and where you can come and inspect the originals. Each party will have to do that. Failure to serve list of documents, or if list is inadequate, the other party can apply for further and better discovery. Okay, so you also have to explain the process of applying for further and better discovery. And if the other side, well, I believe Angela is hiding some documents which I know exist, then I can apply for specific discovery. Notice the difference between D and E and don't confuse it. Okay, here I'm giving you the skeleton. Go through about the requirements in your lecture handouts. Okay. Between D and E, D is a more general. Okay. Either the other party did not serve list of documents, or you know there are other categories of documents that should exist. You go for further and better discovery. Point B here. But if there are specific items that you know exist but the other side has not disclosed, such as, for example, you know there's an inspection report. Remember atomic construction inspection report? Because it's been mentioned, I know there must be an inspection report. Those are specific documents are after. Then it will be specific discovery. Okay? So you understand the difference. You also, for the purpose of discovery, you also have to explain what is meant by privilege and on what basis, what are the different types. There's no automatic privilege. Any privilege asserted there must be reasons stated. Okay? The claim must be made with sufficient statement of the grounds of the privilege, examples, and what each one is about. Now, legal professional privilege. There are two types, right? One is communications in contemplation of litigation. The other one is general solicitor-client advice. Okay. Without prejudice communications. What's the C name again? Without prejudice. Save as to cost. Okay, remember the two limb. Without prejudice meaning it should not prejudice the merits of the case in front of the trial judge. Okay? So no disclosure to trial judge before the final judgment or the substantive issues are decided. Save as to cost, meaning without prejudice to the case, but yes, there can be prejudice or implications on cost issues. So again, at the main trial, the judge will be told of any such communications without prejudice offers, sanction payments, sanction offers, and so on. And the judge will take those into consideration when giving cost orders. Privilege against self-incrimination, pretty self-explanatory. Public immunity privilege, so the disclosure of such information would harm public interest. Okay, so that's public immunity privilege. Any questions? Okay. Payment mechanism under 13A, that's your question 9. Assume that in a breach of contract action, the plaintiff has served the writ claiming $2 million against the defendant as liquidated damages. What advice would you give the defendant if she does not wish to contest liability? She cannot pay the damages in one lump sum. Okay. So you have to explain the mechanism and the purpose under Order 13.A. So under the facts given, the defendant not disputing liability or quantum. You're told that it's a liquidated damages, so it's a fixed sum. So quantum is not disputed either, but have difficulty in paying in one lump sum. You would advise that the defendant can admit the claim, liability, and quantum under Order 13A. It would allow the defendant, normally it would allow the defendant to admit the whole or part of the claim and suggest payment terms. In this case, it seems the defendant would admit to the whole claim. Right? There's no suggestion otherwise from the question. Right? Only about payment method or timing. Order 13A only applies to monetary claims. hence is applicable and suitable in the present case where the defendant wished to admit liability and content. Right? First, you will explain that accompanied with the writ, when the writ was served, remember one of the documents is the AS attached to the writ. The other document attached is either a Form 16 for liquidated damages or Form 16C for liquidated damages. In this case, because it's liquidated sum, Form 16 would have been served accompanied with the writ when the writ was served. Okay. You have to advise the client, the defendant, that if he admits the claim, in this case in whole probably, the admission is binding. On the same form, the defendant will be able to make disclosure or disclose his financial status, including income and expense, assets and liabilities. The disclosure made must be full and frank disclosure. Okay, nothing to hide, cannot hide from hide assets or things like that. Okay, cannot hide any details. You can also suggest terms of repayment, such as by installments, length of time, amount for which installment, etc. The completed Form 16 admission form must be filed and served within 28 days after time limited for AS. Consequences. If the plaintiff accepts the offer, the action will be stayed as long as the defendant continues to pay by the specified installments. If the plaintiff rejects the offer, the plaintiff can state his proposed terms of payment. If the terms of both parties are different, the court will make a determination. If the parties are unhappy with the court's terms, suggested terms, then they can ask for a determination once. Okay, they can ask and go on forever. So they can ask for the court to determine once. Okay. Remember, while the defendant continues to pay by the specified installments under the court order, the action will be stayed. However, if the defendant defaults in the payment under Order 13A, then the plaintiff can enforce the judgment on the remaining unpaid amount. Pretty simple, right? It's just very factual. Any questions? I'm not giving you another break because we are sort of not very far from the end. Unless you fiercely object. The stages in civil trial this is almost a rerun of our trial process. And so you would explain, as with any other question, explain which rules govern the trial process. Explain that normally in normal civil cases, whether it's at the court of first instance or whether it is at a district court, it would be trial before a single judge. Burden of proof on plaintiff as the one asserting the claim. Standard of proof on a balance of probabilities, or otherwise more likely than not. Okay? Another term for it is more likely than not. The balance of probabilities is 10. Rerun of our very recent lecture, right? Was it very last one, right? Was the very last one? The trial in the world. Stages. Plaintiff's opening address. Plaintiff's evidence for each of plaintiff's witness. Remember evidence in chief. So for each witness, they will go through these 3 steps first before the next witness is called. So examination in chief, meaning the main evidence. Normally done by adopting the witness statement. Okay. Nowadays, no amplification is allowed, pretty much. Very rarely, the plaintiff's counsel may be allowed to ask 1 or very few questions if they want to clarify something. Then it's cross-examination by the other side, the defense, to challenge the plaintiff's case. After cross-examination, the plaintiff side may re-examine, may have the examination of that particular witness for issues arising out of cross-examination. Okay? Only for issues arising out of cross-examination. Then is the close of the plaintiff's case. After that is the defendant's opening address and the defendant's witness. So for each of defendant's witnesses, we go through the same 3 steps. Examination in chief, cross-examination, and re-examination. Then for the closing address, the defendant goes first and the plaintiff closes last. Remember, as I told you, the plaintiff being the one bringing or commencing the claim has the first word and the last say. Okay, so they start first and they end last. Then judgment may be handed down, most likely in civil trials, on another day. Pretty simple. It's just a requirement to be able to outline the stages and briefly describe what each stage is about, the purpose and how it's done. Okay, pretty much just like a flow chart. Right? Please do not use a flow chart as your answer. Okay? If you want to draw a flow chart in addition to your answer, if you're dying to, yes, but please don't use it for your answer. Okay, any questions? I don't believe I've missed any questions from the answer booklet, and as in your revision booklet. Any questions on any of the substantive topic? Really? Okay, have a few minutes to think about it. Now, I don't have any more substantive material to share with you. This is pretty much probably very cliche to you. Okay? Probably every single teacher talks about that. How to study for the exam, review your materials, learn your essentials. Do you still remember what I said should be in your toolkit? The 2 things? Definitions, legal principles, and authorities for 1 and 2. Okay? Definitions, legal principles, and authorities for 1 and 2. Regardless of whether the question asks you, cite any relevant or all relevant authorities, whether it's statutory provisions, new numbers, case law. I may have mentioned this, but I'm a bit confused now because I've gone to the revision lecture. Go through past papers. I think some of you may have already tended to that. You're given past papers from here. It gives you an indication of the style of questions that you're likely to be asked about. It may also give you some indication about which questions are likely to be half questions or full questions. You should first completely organize your notes, your own notes first, then run through past papers. To do so, it would allow, sorry about writing this, it would allow you to estimate whether you can finish your question within the limited time. Okay? If you don't have time to write down full answers, you should at least run for each question or each topic, you should at least run once. Okay? You should write full answers, practice at least once to time yourself. For the others, you may say, okay, I already practice with one summary judgment question. I think that's good. My timing is good. I can finish my answers within time. For the others, just at least have a peek through them to see if the question can be asked in other different ways. Okay, in this subject, the questions tend to be appearing in similar format, but for some other, they may come in different format for other subjects. If this module tends to be pretty simple in that the questions are asked pretty much in very similar ways. Okay, in your other subject, you should be aware. When you do revisions, try to rotate. How many subjects have you got? 5?
Yes.
5 subjects, how many questions each? In your obligations or business associations? 5, 8, 3? Do you all have short questions and long questions? All of them? Okay, so you have multiple topics. I would say at least 5 questions, if not 8. How many? In this topic, we have... I've gone through this. When I mean rotating for time, here. Okay, for this module, you have section A, 3 out of 5 questions. Section B, 1 out of 2. Is that for this subject in general? Yes? All subjects are like this? Okay, so you have 4 questions. Right. First of all, please choose your topic carefully. When you choose topics, concentrate. I think at this level, you should study all topics. And do you still, I know some students try to pick topics and concentrate, but it's quite dangerous. Okay, so you have to take your own risk. If you think, okay, I will only choose and study however many topics, be careful. Okay, secondly, when you choose topics and study, rotate your study. So 4 questions, 5 subjects, so 20, right? 5 subjects, 4 questions, correct? 20. You have to write 20 answers during that period. 4 right? 5 subjects, 4 questions each, if you are correct in saying every subject is like that. So rotate your topics, because you have got, although you write 4 questions, you have at least 7 or 8 topics to study, right, in each subject. So rotate your studies, as in, don't go, okay, I'm studying business associations this week. I will, or this, I think business associations is so difficult. I will study that first and spend 3 weeks on that. Because your final exams are within 2 weeks, everything is done within 2 weeks or so. Is that correct? Right, so you don't have time to, okay, now I'm comfortable with business associations. Let me move on to obligations. Also, when you start to study once, you don't remember it clearly enough. So when you should mix subjects as well as topics when you rotate, so that you don't leave any one subject, or that would be my recommendation. You can do it otherwise. But try to rotate that, okay, obligations I run today, and then do it periodically. Don't do blocks. Do you know what I mean? You understand what I mean? Right? So that you keep your memory afresh. If you do 2 weeks or 3 weeks business associations and do 3 weeks obligations, you would have forgotten all you learned from business associations. So totally abandon, okay, in blocks. Go through that. Case authorities. Okay, names of cases must. Legal principles must. Facts, to remember the facts, mostly not necessary. When you remember the case, it's only mandatory. The essential bit is the ratio. So only remember the legal principles and the case citation. Okay, that's good enough. Don't go in the exams to regurgitate the facts in the case, in that precedent. Then you're wasting your time. Unless in an assignment, only in an assignment case that you find a strikingly similar facts, then you can say, oh, okay, I better mention those facts. Otherwise, it's not necessary and definitely not doing sense. Level of court, and well, we expect you to remember the names of the case. If you can remember the year, good. But the rest, okay, 2 HKLRD 503, not necessary. Statutes, you have to remember the name of the statute, subsections, and sections and subsections. Okay, so it is section 23, bracket 1. Remember section 23, bracket 1. Of course, the next best is section 23, right? Whatever details you can remember. I think I mentioned last time, in terms of case authorities, if I can't remember the year, what happens? Will I be redecriminalized? Depending on what the lecturer tells you in each subject, I know different lecturers for different subjects sometimes tells you, yes, you have to remember the year, and some says you don't, some say you don't. I used to try to remember the years, but if it's a difference between, okay, if I forget about the years, I may remember another 20 case names, then remember those additional case names is more beneficial. Also, remember for each legal principle, theoretically, you only have to cite one case authority. Okay? For invitation to treat, you do not have to mention pharmaceutical and Great Britain and Fisher and Bell and another case. Okay, one is enough. Choose the closest one that is relevant. What else? Goes without saying, read the questions carefully, choosing which questions to answer. Deal with all parts of the question, and sometimes the unwritten part. Just like what I told you, right? We asked you to explain the procedure of Order 14. You also have to explain the principle. Okay? Although that is most of the time not written in the question, you expect it to. Okay? Be careful. This is not as much applicable in this subject. When you ask a question, be careful whether you're asked to simply state or explain the facts or information. Are you meant to criticize or evaluate? Are you meant to agree or disagree on a statement and state why? Okay. In some subjects, not so much in this subject. In other subjects, when you are meant to criticize or evaluate, you may find it beneficial to suggest reforms. It's such as, for example, the legal system. If you're asked to criticize the current jury system, the current CFI jury system, if you criticize, think about the unasked part of the question. If you're asked to criticize, it means there is something wrong. Okay, so you can get extra marks by suggesting reforms. Right? And vice versa. If you ask about what reforms have been proposed, it must have meant that there is some pitfalls or disadvantages or shortfalls in that system, which you may also get a few marks if you identify them. Okay, so this doesn't go as much on this subject, but rather on others. If you have a long question, consider drawing a quick plan. Goes with all your subjects as well. I wouldn't say if it's a short question, I wouldn't really spend the time, but if it's a long question, you may like to jot down something very, very simple. Okay, it's only for your benefit, so you don't need to lay it out nicely, just jot down. Okay, we've talked about this. Allocate time according to marks. This used to be my pitfall. I used to be not disciplined enough in my studies and when I write exams. Okay, when I write questions, I keep on thinking on a long question, I can write just that little bit more to make my answer perfect. It's not worthwhile. You allocate, remember, really allocate the time according to the mark. The first, that's what all your teachers will tell you. The first half of the marks is easy to get. It's only when you try to get, it's easy to get a pass in a question. So if you try to write that extra bit on a question that you've already answered 70-80%, you get very few additional marks by doing that extra bit. But you may use that 15 minutes in the next question and get a pass already. Okay, so don't pull yourself tight on time. Okay, that's all I have to share with you tonight. I'll stay back for any questions. Okay, so I'm gonna hand it to